Good evening and welcome to the Connecticut Mirror's annual look back at the Supreme Court's recently completed session. I'm John Dankosky of the Connecticut Mirror, and we're joined tonight by readers of four other statewide nonprofit news organizations. We're very happy to have readers from VT Digger, Spotlight PA from my home state, Colorado Sun, and New York Focus, as well as members of the World Affairs Council of Connecticut. Thanks also to the generous financial supporters of Connecticut Mirror's event series, our presenting sponsor, Eversource, amplifying sponsors, CBIA and Mohegan Tribe, and publishing sponsors, CLA, Express Strategies, Hinckley Allen, Rowthorne Law, LLC, and the Causeway Agency. Our panelist this evening is longtime New York Times Supreme Court correspondent Adam Liptak. Adam's a Yale Law School graduate and a 2009 Pulitzer Prize finalist. Adam, thanks so much for doing this. Welcome to our program.
It's great to be here, and I want to tell you I have deep Connecticut roots. I was born and raised in Stamford, Connecticut, went to Stamford High School. As you say, I went to law school in New Haven. I also went to college in New Haven. So I have a lot of affection for Connecticut.
Yes, and we're very glad to have you here in your home state virtually. Now, if you've got questions for Adam, you can use the Q&A function at the bottom of the page. Just a note here, we won't be able to get to all of your questions, of course. Some of them might be coming in as duplicates, so we'll try to condense along the way. I'll also say that this was a very intense and active Supreme Court term, as you'll hear, so we might not get to absolutely every issue, but we'll try to, in the next hour, cover as much as we possibly can. So, first of all, because this is the first time we've actually done this, Adam, I'd love to talk to you for just a second about how you think about doing your job of covering the court. I mean, what do you see as your role as someone who covers the Supreme Court for a big national audience?
The basic job, and there's a lot of elements to it, but the basic job is to translate complicated legal materials into accessible English on deadline. And I think that sounds hard. It is hard. And both pieces of it, making sense of the jargon, understanding it, getting it down on paper in something like English and fast, is a challenge.
How long did it take you in doing this job to feel like, yeah, I kind of got this? Because it does take a while to figure out how to actually translate the jargon.
I don't mean to compare myself to Supreme Court justices, but the justices will say it takes them about 3 years to get the hang of it. And I'd say it was 3 or 4 years of, some combination of feeling lost and pure terror until I kind of knew how to read an opinion. The other thing that happens at the court is they kind of decide the same cases over and over again. So the first time you get a new area of the law, you're lost, you're baffled. By the second time, this sounds familiar. By the third and fourth time, you go, I know this. So one reason Supreme Court reporters last such a long time, my predecessor, Linda Greenhouse, did it for 30 years. When she retired, she was the third most senior Supreme Court reporter there. I've done it for 17 years. I'm kind of in the middle of the pack. People do it for a long time for just the reason you suggest. It gets a little easier as you go along.
Well, one of the things that, and Linda did this with us for years, and of course Linda has some roots here as well, and we always loved talking to her. One of the things she always tried to do, Adam, I think is, I at a certain point in her career, she decided that she was going to try to paint a picture of certain themes that she would see, themes that the court that were running through the cases or that were running through the members of the court. Is that kind of how you view things too? Like, do you see this as a big play that's unfolding, or do you see this as a series of disconnected cases that are just really separated by the facts?
No, there are certainly themes, although in Linda's day, the themes were fewer and more distinct. And now there are a lot of cross currents. There are kind of interpretive commitments of some of the justices. There are substance matter themes like religion and campaign finance that run through the cases. There are shifting alliances on the court. So I think it's probably even more complicated than it was some years ago.
Yeah, and I would assume that the job, even in your time doing this, has changed quite a bit. not just because of the makeup of the court or the court members who are there, but just the way in which the Supreme Court views itself. Do you feel as though the work has changed over time?
It's changed in a practical way
Mm.
enormously with the rise of the internet and the need for speed. When Linda covered the court, she wouldn't write for the web. And that people didn't even think that was particularly weird. She would write for the next day's paper, so she'd get an opinion at 10 o'clock in the morning, read it, consult with people, have lunch, write a story in the afternoon, file it as the sun was setting over Washington at night. It would be delivered to our readers on their doorsteps the next day. And that would really be the first time people would hear about what had happened, because we didn't have this digital news culture. I now, and this is not an exaggeration, I try to file within minutes. I will have pre-written versions of stories. I will glance at the opinion, which is sometimes very long and sometimes quite complicated with overlapping concurrences and dissents, satisfy myself I have the very basics of who won and who lost right, and post that, and then go back and add a vote count and add some quotes, and only then read it with care, which takes, even I'm a pretty fast reader. It takes about an hour to really get the architecture and the consequences of the case down, and then you file that piece by maybe noon, and then by the end of the day, on the fourth or fifth draft, I will probably have written a story as good as what Linda did, but I will have done it many times. And the readership of the first story is by far the largest. So there's this complete inverse relationship between the quality of the story and the readership, unfortunately.
And I guess I wonder if you can talk a little bit more about what you think that means to the way that we actually understand the work of the Supreme Court and what these rulings actually mean, because the initial readership or viewership, if you're watching it on CNN or listening on NPR, is the largest possible audience that you're going to get for this, and the thoughtful piece 2 months down the road is going to be something fewer people will read. Does it lend to people kind of viewing what the court does in a sort of quick 6-3 kind of way, just counting in a very a clear way, something that's much more nuanced than what you can report just as the ruling comes down?
I fear that you're right, and it plays into a simple-minded view of the court. And I don't know what to do about that, except I do think the second day piece, and the second day piece will sometimes be a first day piece, which tries to step back and put that big decision in a larger context and talk about where it fits in with the court's doctrine and where it's changing and what the alliances suggest and what the practical consequences should be. And those stories get a pretty good readership too, sometimes rivaling the initial story. But you're not wrong that this need for speed turns everybody in the first instance into a wire service reporter. And that used to be a distinct role. And I have nothing but respect for wire service reporters. Really hard job, very important, but not what I hold myself out to be.
Hmm. Well, I think we have a lot of news junkies on this particular call right now at these various publications. So I could probably talk to you about how you do your work for the full hour, but there's a lot of stuff that we actually have to talk to in terms of the work that the court did. The number one question that I got in emails in advance of this, in many different forms, it went something like this: does the Supreme Court exist right now just for the purpose of doing what Donald Trump wants? Now, I'm going to get into some details with you on many of the cases, and I'm sure you'll flesh that out more. But broadly, Adam, when people say, is this Supreme Court right now just here to do Donald Trump's bidding? What do you tell people?
So I certainly wouldn't put it like that, but I understand what animates that concern. And the court has, in the past 6 months, really given the green light to a lot of ambitious Trump programs that test the limits of the law. So there's a lot of evidence for that point of view. This is also a court that has a 6-3 conservative majority, with all of the conservatives appointed by Republicans, all of the 3 liberals appointed by Democrats. That sounds kind of normal. It didn't used to be the case through most of American history. The appointing president didn't perfectly predict how people would vote. 3 of the justices are Trump appointees. Several of the justices are deeply committed to a broad conception of executive power, which I think, for the most part, would be the case, whatever the administration. So all of that helps President Trump. It also is not ideal that Congress has abdicated its role. When the framers drafted the Constitution, they expected there to be checks and balances and separation of power tussles, but they mostly expected Congress, which is in Article 1 of the Constitution, to control the president in Article 2 of the Constitution. And they didn't envision such a leading role for the courts as over the hundreds of years have developed. I don't think we really have seen a showdown between Trump and the court. I think it will come. Most of what we've seen so far have been preliminary skirmishes on what people call the shadow docket, emergency applications decided very quickly. I think, for instance, when birthright citizenship reaches the court on the merits, where they actually decide the constitutionality of it, they're going to rule against the president. So it is, the evidence so far is consistent with what you're hearing, but it's early days.
So let's get into this distinction. These emergency cases. You've actually said this. The term can kind of be viewed in terms of the Trump cases, which tend to be these emergency cases, and
Yeah.
everything else, which we'll get into. Maybe you could just explain the distinction, and also why we are now seeing so many of these quote unquote emergency cases coming through.
The best way to understand the emergency docket is to think about what we think about what the court usually does. The court, the courthouse in Washington has little turtles all over it, little sculptures of turtles, and that is a representation that the court is a slow and deliberate creature that takes its time to get stuff right. So the ordinary case maybe takes a year at the court. There's a round of briefs on asking the justices to hear the case. They decide to hear the case. There's another round of briefs on the merits. There's an oral argument. They meet in their private conference. They deliberate. They exchange drafts, and they produce an opinion that is often, 100 pages long. It's the Citizens United decision was as long as the Great Gatsby. So that's the ordinary. That's the court I used to know. Separately, you can race up to the court on an emergency application on very thin briefs, on no oral argument, on no real deliberation, and then that yields a ruling that often has no reasoning. And that doesn't sound satisfactory, and it's not. It arises, and this goes to the second part of your question, because there have been so many Trump executive orders challenged in the lower courts, and a single district court judge will often say that policy is no good. It's unlawful. It's unconstitutional. The appeals court is asked to pause that ruling while the litigation goes forward. The appeals court declines. It goes to the Supreme Court. And for the most part, the court has been saying, we're not going to tell you if it's lawful or not, but we will tell you that we're going to leave it in place while the litigation goes forward. We're going to stay or pause that initial lower court ruling. And this has happened over and over again. We're up to like maybe 20 times. And Trump has been almost always winning. And an unsatisfactory part of it, which I mentioned, but I'm going to dwell on, is that some of these decisions, like yesterday's decision dismantling the Department of Education, comes with no reasoning at all. And that's just a very odd thing, because the elected branches claim power because in a democracy they've been given power. The courts claim power by reason, and if you don't have reasoned opinions, you're in a funny situation.
So talk more about that. There's no reasoning given because of the speed with which they have to work. No reasoning given because they don't feel like they have to give a reason. If all they're saying is let's leave the law in place, or leave it in place and decide it later.
So partly it's the norms and conventions of the court that when an emergency application for a stay reaches it, they don't typically give reasons. Justice Alito has talked a little bit about this, and it's not wholly crazy. He says we need to make sure that every word we write, which creates a precedent, is well thought out and anticipates all kinds of situations. I was just reading over this. He said in a speech, we're not like journalists who can just dash off a story. We have to do it just right. And sometimes it's better to say nothing than to say something that lower courts and litigants are going to misinterpret.
Nice. So he's able to take a shot at these journalists who write sometimes, as you said before, 10 versions of the story, Adam. I know. Exactly.
I quoted that in a story that's going to run tomorrow morning, and my editor was really offended.
I can see that, but I think it is interesting. I mean, if getting back to this notion, this construction that you made before, that what the court does really derives its power from the idea that they can explain themselves.
Yes.
In the absence of that, really, why do people listen to what the Supreme Court, or frankly any court, says?
Right. I mean, it's an assertion of power, just naked power, and that is hard to sustain over time. In the court,
It
the
Yeah.
court
Go ahead.
has legitimacy, it hopes, and you say, well, what is this legitimacy thing you speak of? And it's really you trust them because they're able lawyers who are experts in the law, and you may not agree with every single decision, but you see how they got there, and that's what gives the court its authority. And without that, as you're suggesting, we're in a different place.
So to dig into this a little bit more, let's talk about this birthright citizenship case, and which is nominally, of course, about the constitutional idea that people born in the country are granted citizenship. You say that the case that the court has ruled on so far is really about the court's ability to limit the president's agenda. So I want to just take a pause here and say, earlier in our conversation, you said that if a case came to the Supreme Court, when a case comes to the Supreme Court that is about the merits of birthright citizenship and its constitutionality, you you say that you feel pretty confident that that's one that Donald Trump, who wants to end birthright citizenship, you feel confident that's one he'd lose, right?
When they get to the merits, when they get to the legal question of does the Constitution guarantee birthright citizenship, it is the consensus view of legal experts, court watchers, and me that the Constitution does guarantee that right. And if it's going to be overturned, it's going to be overturned by constitutional amendment, not by statute, and certainly not by a president's whim.
But the court case that came up during this term wasn't exactly that, and it really had to do with something else. So could you sort of walk us through that?
Yeah.
Because this really does have to do with the power of the court and the role in lower court rulings.
So 3 different federal judges around the country said what I just said. Birthright citizenship is constitutionally guaranteed. They did that in the context of lawsuits brought by immigrants, brought by advocacy groups, brought by states. And in those 3 rulings, they said, you win, you get the benefit of this ruling. No one's going to take away your children's and prospective children's citizenship. And also, everyone else across the country gets the benefit of these rulings. And that raises a question which has long troubled the courts and which has given rise to criticism across the ideological spectrum of should judges have that right to issue what some people call nationwide injunctions, but it's really not about geography. It's about who's before the court. So the better term is probably universal injunctions. Can a judge bind people, give people the benefit of a ruling when they're not actually before the court? And so having lost on these 2 grounds in the lower courts, Trump's lawyers go up to the Supreme Court and they only ask the court to look at the universal injunction question. They say, let's leave the constitutionality of birthright citizenship for another day. Just tell us the answer, would you, to do judges have this power? do they have the power to issue universal injunctions? And I thought it was a terrible vehicle. It's an important question. It deserves an answer. The universal injunctions are kind of theoretically problematic. The worst possible situation to decide it in, because are you really going to have a world where in Kansas, if you're born there, you're not a citizen, but in New Jersey you are? And what if you move and does your citizenship turn off and on? Like, I mean, it's just a mess. But the court decided to take it, decided only to decide that question of universal injunctions, and said courts, as a general matter, do not have that power. Gets rid of universal injunctions. There's a footnote, maybe states, in order to get complete relief, have to get national relief, but basically they say it's not going to work. And that, was a huge win for President Trump. He called it a monumental victory. He's not wrong. The court did leave open another way to get to more or less the same place. We'll see if it works, which is for people to sue as a class action. And if that class of people is all before the court and the court shuts down the program for the entire class, you've basically gotten to the same place. So this may be an argument about procedures and nomenclature, and maybe a little less big than we thought it was, but remains to be seen. Just the other day, a court did provisionally certify a class action and issue a preliminary injunction against birthright citizenship. Birthright citizenship is again off the table. It'll probably go to the court over the summer. We used to get the summers off, no more.
But I mean, so many things to unpack in there. I mean, one of them, of course, is if you're talking about class action lawsuits, they're notoriously hard to put together. They can be very, very costly. That can take an awful lot of time. It suggests that only some people with some resources can get in front of the courts with a case like that, and it seems like that, Adam, is problematic.
Justice Sotomayor, in her dissent, made precisely that point, that some of this thinking is going to create like two classes of people: the ones with the wherewithal and the money to file suits, and everybody else.
Now, you had mentioned that the legal argument for the universal injunction itself may be kind of problematic, and it's not something that has a ton of precedent in history, right? This is something that it's relatively recent compared to,
Yes.
say, the Constitution.
People argue about it, but the '60s, the '70s, and it really takes off in the current century. Um, and it's kind of an artifact, an emblem of a world in which courts are playing a larger role. The president, and not only Donald Trump, other presidents are testing the limits of presidential power. There's a lot going on here, a lot of clashes, and people are using every tool available to them.
It's interesting because I think some people have certainly read and opined that some of the rulings of the Supreme Court take power away from the lower courts, but it feels to me like what we're entering into is a world where the only time you can get relief from anything is just by suing, because it's got to get to the courts somehow. And I'll be damned if your lawmakers are going to do anything about it, because as you said, Congress seems to be sitting this stuff out. I mean, does this just mean more court cases, many more cases like this, that not only get up to the Supreme Court but have to be ruled on by lower courts?
I cannot disagree with you. The one point I'd make, which doesn't go directly to your point, but is kind of a third alternative to how else you can get nationwide relief. If you can get to the Supreme Court and it issues a ruling, that ruling, everyone agrees, applies nationwide. So it also even if it decreases the power of lower court judges, it increases the power of the Supreme Court.
And I may be jumping ahead in the conversation that I wanted to have, but I might as well ask it now because it seems appropriate. There's also been questions, and you forecasted this earlier, that there could be a time at which a President Trump or some future president really does have a clash with the Supreme Court. I mean, what's the mechanism, Adam, for the Supreme Court ruling that something is illegal, and the president saying, No, I'm actually going to do it that way anyway because I'm the executive and I can.
That's the nightmare scenario. That would be a full-blown crisis. The court does not have a lot of tools. People agree to do what the court does, as we were talking about before, because they trust it. They believe it should have the last word, even if people disagree with given decisions. It doesn't have an army. It doesn't have the power of the purse. I mean, in theory, you could hold someone in contempt and then ask the Justice Department, controlled by the president, to pursue an official. No, I mean, listen, this is a huge problem and one the court wants to try to avoid. So much so they never say this, but they're going to pick their fights. They're going to want to rule against the president on things that have broad acceptance and on things that are hard to disobey. And birthright citizenship, I think, satisfies both criteria. Hardly overwhelmingly, but a good majority of Americans who understand the issue believe the 14th Amendment guarantees birthright citizenship. And if you don't like it, amend the Constitution. And also, if they rule against President Trump on this, it's a little hard to know how he disobeys it. I mean, he's going to what? He's going to instruct hospitals in given places to issue birth certificates to some people, but not others. It's hard to implement, even if it hasn't been struck down by the courts, and if it has been, even harder.
Back to this case. I mean, just in the nuts and bolts of it, though, we suggested earlier that probably don't want to live in a world in which babies that are born in Alabama are not U.S. citizens, and people that are born elsewhere are. We're not close to that point with these rulings, are we? Where we actually have a patchwork system of laws,
No,
or are we there?
no, we're not there yet. The program has been enjoined from day one. It has not come into effect. Make a note, because if I turn out to be wrong, I'll be quite wrong. I don't think it will ever come into effect.
But back to some of the court action around this. One of the things that was fascinating about this particular ruling is Amy Coney Barrett writing for the majority, Ketanji Brown Jackson writing a dissent, and it's interesting that we have these two jurors who are junior members of the court who are playing such prominent roles. I guess I'm just wondering if you can talk a little bit about the dynamics between these two justices.
So Amy Coney Barrett has been the focus of a lot of attention. She's, of course, the third Trump appointee. She has shown some signs, and it's easy to overblow these things, but some signs of independence. She's occasionally joined the three liberals along with the Chief Justice in relatively minor cases to rule against Donald Trump. And she's also a former law professor, and one who seems to take the law seriously enough that if the law seems to compel a result that she might not like as a policy matter, she will do it. So she's been an interesting figure. And for her to get such a big decision assigned to her, the Chief Justice, when he's in the majority, assigns the decisions, to give that to a junior justice was quite interesting. Now, so she's the second most junior justice. The most junior justice is Ketanji Brown Jackson, appointed by President Biden 3 years ago to replace Justice Breyer. And she has been very, very active on the bench and in writing separate decisions. She has written uh, more concurring opinions. Her rate of concurring opinions is the highest of any justice since 1937. So she often expresses herself, takes a view, and in the birthright citizenship case, the universal injunction case, after Justice Sotomayor, writing for the three dissenters, both Kagan and Jackson joined the principal dissent, she writes her own dissent, and she really sounds an alarm. She's going, people, pay attention. This is dangerous stuff. This is an existential threat to our democracy. And goes on in that vein. Having read that, Justice Barrett, who is basically quite collegial and even kind of formal, really lashes out at Justice Jackson and says that she is not talking about any recognizable law or doctrine. She's talking about something else. She doesn't say what, but she's suggesting that it's political criticism in a setting where you want to be arguing about the law. So they present two starkly different views of what's going on here.
From your reading of this, do you sense that uh, Justice Jackson's dissent comes from a place of politics or comes from a place of looking at what the court has done so far over the course of these last couple of years and saying we're we seem to be handing an awful lot of power to one individual in a number of different ways.
So my going in view is that all of the justices are acting in good faith. They're not disguising their views. And I think Justice Jackson is writing in what she understands to be constitutional terms, not political terms. And really, and not a few people share this view, really believes that in a matter of months, our democracy is being undone. And that's a point of view you can agree with, you can disagree with, but if she earnestly believes that, she should say it.
We have a bunch of questions coming in from folks, and I want to get to a few of these because we have some other cases that we want to talk about. John writes us and says, "How would you rate Chief Justice John Roberts' effectiveness as a Chief Justice compared to some of his predecessors?" And I'll just amend that to just maybe have you talk a little bit more about what the overall role the Chief Justice has had during this term.
The Chief Justice job is kind of odd. You don't get a lot of extra power for being chief. You still get the same one vote. As I mentioned, you have the assignment power when you're in the majority. That's not nothing. You have some administrative role in setting the agenda about when cases are argued and so on. But you don't really have a role other than kind of setting the tone. Um, the Chief Justice is an exceptional writer, smart lawyer, good administrator, not always as popular with his colleagues as, say, his predecessor, Chief Justice Rehnquist was, but much more popular than Chief Justice Berger. How is he doing? He was in the majority more than any other justice this term. So that's a statement about where he is and his ability to lead the court. At the same time, this 6-3 court is kind of an odd configuration. It's a little hard. You really have to build coalitions to do anything unusual. And while there were only 6-3 decisions in the classical lineup with the Republican appointees versus the Democratic appointees, several of them were in the biggest cases.
If you could talk a bit more about that coalition building, because I think for many people who look at the court, as we said earlier, just by reading the top line of it, they'll say, "Look, it's 6-3. It's Republicans versus Democrats. What coalitions do you need to build? These guys are always going to vote like this, and these guys are always going to vote like this." Talk about how that's not exactly always the case.
There were some examples of the Chief Justice and Justice Barrett joining the liberals. For instance, a couple of days before President Trump was inaugurated, there was a question of whether he should have to be sentenced in New York State court for 33 felonies. And 5-4, with the liberals, the Chief Justice, and Barrett in the majority, they said yes, he did have to. That kind of drove people crazy. Some people. That same coalition briefly pushed back against the suspension of USAID funds abroad. That caused some on the far right to really go after Justice Barrett, calling her a DEI hire. And even a small deviation from the Trump agenda gets a huge response. And yet there are occasional, to be sure, minor exceptions to that 6-3 makeup of the court. And let me say, too, they're unanimous like 40% of the time. Not always the biggest cases, but the court works hard to find consensus, and really not some reasonably significant cases. So in one case, they were unanimous in saying that members of majority groups have to face the same standards as members of minority groups in employment discrimination cases. They were unanimous in saying that Congress had barred lawsuits that Mexico sought to bring against gun manufacturers. They were unanimous in saying that Wisconsin was wrong not to allow a Catholic charity a tax exemption. Not blockbuster cases, but not nothing either, and they were unanimous. So while, no doubt, the very biggest cases often split in the usual way, it's not the only way they split.
Hmm. I want to get to a few more things. This was a question that came in from a reader to the Mirror, Ernesto, who says the U.S. Supreme Court gave a green light to the Trump administration to mass firings across federal government. I might not agree with such a decision, Ernesto writes, but I believe that the head of the executive branch is entitled to make such a decision. I wanted to know your opinion about the Supreme Court's decision.
So I don't agree or disagree with Supreme Court decisions, at least publicly. But that's a valid point, and that's a point that it's possible to say, I don't think it's a good idea to fire all these people. I think that's a bad policy. But the president runs the executive branch, and the president is allowed to make foolish decisions. And that's a respectable point of view. And on the right, there's a legal doctrine called the unitary executive theory, which says Congress can't tell the president what to do about how to run his own branch.
Of course, and we'll get back to this a little bit more. But you'd mentioned earlier the role that Congress plays in all this. I mean, I think one question that many people have about this, and it doesn't come up in each one of these cases, but Congress is the entity that funds these programs that the Trump administration is cutting, and uh, many people take a look at that and say, well, that doesn't allow us to have the separation of powers that we're supposed to have in this country. If the Congress writes the check and says this is what we're going to fund, even if the work ends up being done in the executive branch, you can't unilaterally just change the work that Congress funded just because. And by the court saying, well, yeah, he actually can, it does set up a little bit of a tricky situation for the people who write the laws in Congress, doesn't it?
Yes. Now, I don't think the court has flatly ruled that the president is allowed to refuse to spend money by the end of the fiscal year that has been committed to a particular goal. Uh, and I don't know what the court will do there. My sense is that your view correctly sketches out what the law requires. And it's not for the president to second guess Congress if they explicitly direct the payment of federal money for particular purposes.
Another question that sort of goes to some of these points we're making. This comes from Roger. It says, where do you draw the line legally between a robust executive and an authoritarian or even dictatorial one? And I suppose this question isn't so much for you, but maybe a question for how the court views this. I mean, how do you see this court viewing the idea of an executive branch that is robust? Yeah, we can do what we want here, and where exactly is that line for this court as it goes over into authoritarianism? We can do whatever we want, whatever we want.
Let me answer that question this way. At the end of the last term, on July 1st of 2024, the court granted then candidate Trump substantial immunity from prosecution. And that was, important, of course, and it also ran out the clock on the prosecution in DC. But in the course of doing that, the court sketched out the beginnings of an answer to that question and said, to the extent the Constitution has given the president core responsibilities that can't be second guessed by the other branches, we're not going to interfere. And that one example is the pardon power. Most everybody agrees the president can pardon whom he likes, and he's used that power quite aggressively. It also said the president gets to run the Justice Department and can decide whom to prosecute and whom not. That starts to slide into a more dangerous area. And in this majority opinion by the Chief Justice, it said we're not going to decide all these issues. And if it's not a core part of the president's job, then there's a role for the courts. But it seemed like the core part of the job was pretty wide. And so they anticipated and maybe emboldened President Trump in his second term by understanding that they wanted a very energetic, vigorous president.
When it comes to rulings like the one that does allow large scale firings at the Department of Education, what is the next legal step that happens now? Is this a case in which we will have a series of lawsuits brought against the administration, and then they will eventually have to get back up to the Supreme Court and be actually decided on the merits? How exactly does this work when you have such an onslaught of these types of cases and types of executive branch actions?
That's the idea. The idea is that these are provisional rulings. We're not going to stop them right now. We're going to continue to litigate. Maybe after the appeals court rules, after the Supreme Court gets the case, maybe we'll rule against the president. Maybe we'll then, 18 months from now, give people their jobs back. It's just not realistic. These are fundamentally irreversible rulings. And I was just reading a law review article that looked at 250 instances where the court had let a program go forward, and then it returns to the court. In all 250 of them, it ruled that the program was lawful. So this is a powerful preview. A, on a practical level, it's irreversible. B, when it gets back to the court, they're going to go the same way.
Can we talk for a bit about some of the rulings of this court on LGBTQ plus and trans right issues? It's hard to keep track of them all because there were a number of important cases, but they include upholding a ban on trans youth from accessing puberty blockers and hormone therapy in Tennessee. And also they've said that they're going to decide next year whether states can ban transgender students from playing on sports teams. I guess I'm wondering if you can talk broadly about these cases and whether or not we should be looking at these as a group, essentially, of ideas that the court is tackling together.
Yeah, I think so. It wasn't long ago that we may have reached the high water mark for gay and trans rights. So it's only 10 years ago the court established the constitutional right to same-sex marriage. Huge decision. Then 5 years ago, the court says that a federal civil rights law bars employment discrimination against gay and transgender workers. So you feel like you have a theme going here. And I think that theme has stopped. The court, for instance, said that a web designer has a First Amendment right not to create websites for same-sex weddings. In this last term, as you say, it upheld Tennessee law and laws in 20 other states that forbade some kinds of transition care for trans youths. In a case about religious objections by parents to what was taught in schools, the court said that parents could pull their kids out of classes where storybooks with gay and transgender themes are discussed. And then next term, we have the transgender athletes case that's very likely to go against the athletes. And also a case from California, which, like many blue states, bars conversion therapy by licensed professionals and forbids them from trying to convince kids who understand themselves to be gay or trans from trying to talk them out of that. So we will soon have, I think, decisions saying red states can ban transition care, but blue states can't ban conversion therapy. Not exactly the same cases, but still, big picture, we're not going to see further expansion of gay and transgender rights, and we probably see some retrenchment.
And the retrenchment will likely look like that patchwork that you're talking about, with some states maintaining the rights that they have and other states backsliding in that way.
Yes, and also an aggressive use of religious dissent uh, to be a vehicle to constrain the rights of gay and transgender people.
It's something that I think a lot of people ask about and talk about. I've never gotten a chance to ask you this, so I'll ask you this. You know these folks and you've covered them for years. How much does the individual religious beliefs of the justices come into play when it comes to their rulings?
They insist it does not. I'm not going to second guess them on that. It has been for some time. It's been a court dominated by Catholic justices, and for the most part, actually, let me back up. That's been a decent predictor of how they vote in abortion cases, although Justice Sotomayor is Catholic and went the other way. Catholic doctrine is against the death penalty, and there's no sign that the Catholic justices are following that doctrine rather than the law.
We have another question from a reader here. It says the court has eroded the power of administrative agencies to regulate in their areas of expertise. Is this a huge deviation from decades of precedent?
Yes. Last year, the court overruled the foundational precedent deferring to administrative agencies' interpretations of statute. The case was called Loper-Bright. The precedent was the Chevron precedent. And that's of a piece with the court's hostility to administrative agencies, independent agencies. And to an extent, I don't want to overstate this, but a kind of hostility to expertise, with the idea that judges, and particularly Supreme Court justices, are better situated to decide complex technical matters than people with PhDs.
Which doesn't sound on its face to make much sense to most people, but yet that's kind of where we are at this point, isn't it?
Well, I mean, I can recite the arguments going the other way. I mean, this is Congress passes a statute. Someone's got to interpret what it means. Is it the unelected bureaucrat? Is it a Article 3 judge? If you frame it in those terms, it doesn't sound all that crazy. And we are in a climate where many people authentically think that the government agencies, the deep state, is a problem. So it does all fit together with a certain worldview.
You mentioned this earlier, and we didn't exactly, I think, invoke this term, but we got a lot of people asking about just the concept of the constitutional crisis. What does that mean to you? When do you feel like you can invoke, yeah, this now is a constitutional crisis in your mind?
February. We are in. You call it, I'm happy to call it a constitutional crisis, or at least a fundamental restructuring of the American constitutional order. There's no question but that we're in that space.
So say more about that. That feels, because obviously there's a lot of Americans who would feel that that's very extreme, and they say, well, um, you know, this court is ruling, for instance, for a strong executive, and maybe at some point we'll have a Democratic strong executive who'll swing things back in a different direction. You know, it feels extreme to some people to say this is a constitutional crisis since the start of this year, but that's where you are
Yeah,
right now.
so maybe it's not a crisis. I mean, a crisis is in the eye of the beholder, but that it is radically different, that it's a whole new thing, that this president is claiming powers that no other president has claimed, uh, is essentially unchecked by Congress and the Supreme Court, has an immigration policy that's transformative, has an attitude toward federal workers that's transformative, has an attitude toward independent agencies, toward transgender troops. Um, it's toward whether he has to spend money allocated by Congress. It may be that a lot of people support that, and maybe the Constitution allows it, but that it's a brand new understanding of the Constitution is, I think, beyond dispute.
Do you get the sense though, because given that newness, that's something about the court that I wonder about, and I think a lot of people wonder about is the court set up, and I'm not talking about these individuals themselves, but is the court set up to react in such a new and unusual place that they've never seen this before, but yet they're still kind of acting the same way they've always acted, right? It's strange.
You make a good point. I don't know that I have much to add to that. This court, it's just nine. It's a small outfit. It's nine people. They've got four law clerks each. The world is a tsunami raining down on them. Uh, I'm, I don't think the founders envisioned this kind of role for the courts. So in the next year or two, we're going to have good answers to some of your questions, um, about what role the court will have and whether it's up to the task.
Well, before we run out of time, what are one or two other cases from this term that struck you as something interesting, if maybe not as consequential as some of the things that we talked about, but that were very interesting cases in your mind that maybe told you something about the court?
I think back on a unanimous decision in January. Uh, Congress, by bipartisan majorities, had given TikTok a deadline to be sold, and not be controlled by the Chinese government any longer. It goes to the Supreme Court on an expedited basis, gets a lot of attention. The Supreme Court unanimously rules that that law is constitutional and the deadline has to be abided by. President Trump comes into office and practically as his first act says, I don't care what Congress said. I don't care what the court said. I'm going to postpone that deadline. And he's now done it three times. And that sets the tone. I mean, you were asking, is that a direct defiance of a Supreme Court ruling? Not exactly. It's more of defiance of Congress. But it still sets the tone for this new world. If you'd asked me a couple of years ago, if Congress passes a law, the Supreme Court unanimously upholds it. Can a president waltz in and say, never mind? But that's the lived experience.
But that is interesting too, because it's unanimous. That's another marker in people like yourself who've watched this for a long time say, well, it's a unanimous decision. It's not as though this is something that that people are tossing a coin about. And also, Congress has passed a law. It seems as though that's what we're going with now, right? That's what's so unusual about it. It's not just that this was a close 5-4 split.
Right. I mean, you remember Brown v. Board of Education. The court was very proud that that was unanimous. They thought that would get the opinion accepted in the land. It took a while, but they
Mhm.
tried. In a follow-up case, when the South was resisting abiding by Brown, all 9 justices signed their names. There's this power of unanimity. You think it makes a difference. But I mean, I don't think people have paid enough attention to just how lawless the TikTok experience has been.
Hmm. Looking forward, we've already spoken about one of the cases that the court is likely to hear having to do with transgender athletes. Are there other things looking forward that we should be watching out for the next term?
I can talk about 2 cases. One is kind of idiosyncratic. The other is part of a larger project of the court. They're going to again return to campaign finance and will again almost certainly amplify the role of money in politics. The court is very committed to an understanding of the First Amendment that does not allow most government restrictions on campaign spending. And then there's a case that the court will do the right thing in. It's an appalling case where a Rastafarian prisoner with dreadlocks, whose faith requires him to keep his hair long, walks around because he knows it's in Louisiana. He knows this could be problematic with a Fifth Circuit decision, a federal appeals court decision that says Rastafarians have the right, even in prison, to keep their dreadlocks. And prison officials throw that decision in the trash and shave the guy's head bald. And he is trying to sue the prison officials. So far, the courts have said he can't. I think the Supreme Court will say that we believe in religious freedom enough that it applies to this fellow too.
An interesting case. There'll be a lot of things to look for, and hopefully at this time next year, Adam, you can join us once again to talk about some of these things. I truly appreciate your time. Thank you for taking the time to answer all of my silly questions and all the great questions that came in from our audience.
It was really great to be with you, and the questions were excellent.
They were pretty good questions, right? We had some good questions from people. I want to thank Adam Liptak from the New York Times. I also want to thank all the folks at the Connecticut Mirror who make this possible. Bruce Putterman, our publisher and CEO, the executive editor, Elizabeth Hamilton, Claire Dignan, Irene Mackey, Chris Nilsson, Gabby DeBenedictis, Celia Klotzer, and Robert DeGioia all helped with tonight's program. Thanks also to the generous financial supporters of our event series, our presenting sponsor, Eversource, amplifying sponsor, CBIA and Mohegan Tribe, publishing sponsors, CLA, Express Strategies, Hinckley Allen, Rowthorne Law, LLC, and the Causeway Agency. And thanks to the readers of the 4 other statewide nonprofit news organizations, really great ones, VT Digger, Spotlight PA, Colorado Sun, and New York Focus, as well as members of the excellent World Affairs Council of Connecticut. Next up in our series, In the Room in August, it's a live interview with U.S. Representative Joe Courtney. The date and time still to be announced, but we'll be joining Joe Courtney somewhere in the 2nd District sometime in August. You can go to ctmirror.org/events to find out more about that event. And while you're at the Mirror website, just click on the little button in the upper right-hand corner that says Donate. That's how you can support some of the great journalism that we do here at the Connecticut Mirror. Thanks to everyone from the Mirror, and thanks to you for watching and taking part. Good night, everyone. Take care.
Bye.